I had just taken your lordships to the somewhat egregious provision in Daffen Tinplate. Now, Daffen Tinplate as an authority has to be treated with great care because Mr. Justice Peterson found that the test was whether in fact the alteration to the articles was genuinely for the benefit of the company, and that was overturned by the Court of Appeal in a case called Shuttleworth and Cox Brothers on the basis that it was not whether it was genuinely in the interest of the company, it's whether those passing the resolution honestly believed it to be in the interest of the company, which of course is a different test. But I do just want to pick up, because Daffen Tinplate does have a degree of life after death.
Which bundle are we in?
We are in bundle 2 now, my lord, volume 2 of the authorities, and I'd like to go to tab 19, which is page 1669. Now, this is...
another famous case.
Sorry, my lord?
Another famous case.
Yes. This is a case in which a challenge did not succeed. But if we turn to page 1675 of the electronic bundle, the Master of the Rolls says in the middle of the page there, a paragraph beginning, although.
Yeah.
This case, the Greenhalgh, is very far removed from the type of case in which what is proposed, as in the Daffen case, is to give a majority the right to expropriate a minority shareholder, whether he wanted to sell or not, merely on the ground that the majority shareholders wanted the minority man's shares. Now that could exactly fits the circumstances of our case in my submission, and I'll
this is out a whole step, doesn't it? Doesn't it miss out the question whether they wanted them because they thought it was in the company's interest?
Yes, yes, but no, because I think because of the addition of the word merely.
Yeah.
They want merely because they wanted them, not because they wanted them for good reason or.
What you've got to do in this case, ultimately, is address the judge's findings, upheld in the Court of Appeal, that this wasn't merely because they wanted the minority shareholders, it was because they thought it was for the good of the company.
And I will, after one further reference, if I may, to the authorities. In Bundle 4, at tab 40, which is page 2081 of the electronic bundle. Bundle 4, tab 40, 2081, is a case called Sidebottom and Kershaw.
I suspect it's called City Bottom, is in fact how it tends to be pronounced.
We can call it Kershaw.
At least in the case of the only acquaintance I've ever had.
Right. or both of them sometimes,
Yes,
people
right.
say.
Anyway, whatever the...
Well, it's a passage in Lord Justice Warrington's.
Oh, well.
Yes.
There are some apparently who are more straightforward with
Yes.
pronunciation.
It's a passage in Lord Justice Warrington's judgment on page 2099. This was another case where there was a failure,
Right.
of a challenge to a redemption provision. An interesting case because Mr. Bodden had been involved in the company and a shareholder of the company, but he was actually in competition with the company. And the company thought, well, it's not a great idea to have somebody in competition with us, actually, as a shareholder, and we'd like to acquire his shares. And there was perfectly good evidence about the fact that he may have got information from the company that could assist in competition and so on and so forth. But at the top of page 2099,
Yes.
Because there have been various debates in the authorities about whether merely directing one of these provisions to somebody specifically is of itself mala fides, which plainly it's not. So his lordship is dealing with the submission at the top. That may well be, and that they pass this resolution having had their attention called to it. by the position of Mr. Bodden, i.e. it was directed towards Mr. Bodden. But that's a very different thing from saying that they passed this resolution with the mala fide and dishonest intention of getting rid of a shareholder whom they did not wish to remain in the company. And that's exactly the same point as in Greenhalgh. Obiter, of course, I accept that. But then one asks about, well, where does this mala fides and dishonesty come from? Well, it can come, in my submission, in the exercise of this jurisdiction, from merely the fact that you want to rid somebody of their shares for absolutely no good reason. And that's just simply wrong, and it is in bad faith.
Well, so the distinction from this case is that in this case it was all right because it was had the special object of ridding the company of a particular shareholder who was known to be a competitor.
That's right.
Whereas, all right, and why do you say that in the present case the judge was wrong to?
Well, because there is simply no basis, no objective or even should be subjective justification for the removal of my client as a shareholder.
But if you assess, surely you have to assess it on the basis that the company considered that there was an objective basis. If you were wrong, and if Mr. Cha had made a material misrepresentation which induced Mr. Chen to give him the shares, why shouldn't the company, or why shouldn't the majority shareholder amend the articles to remove someone who has gained his shares because of a material misrepresentation?
Well,
why is that mala fide?
Well, obviously that is the position that we have here when we come down and we ignore all of the other surrounding circumstances. And I've already accepted and indeed averred that there can and should in certain circumstances be these forfeiture provisions where the mere presence of the shareholder is doing damage to the company. Mr. Bodden, or the example of an unfit and improper person that affects a license.
In that context, you could do it retrospectively. If someone had damaged the company by or had obtained his shares through a material misrepresentation, you accept that the company could target a provision towards that person.
Well, it depends upon what is in the interests of the company. Now, because there is a difference here between the shareholders and the company. And we've seen from those obiter dicta that I referred you to that you can't just take somebody's shares because you'd like them. You have to take them for good reason. And a good reason would be for detriment to the company. Let me give you, and this comes back to a point that my Lord Sumption raised, which was, well, in a small private company such as this, what happens if there is a falling out? How do you address that? And of course, the way that you address that on a social level is the majority removes the minority from management and so on and so forth. Now, that might give the minority a right, or at least a claim, to have his shares bought out for unfairly prejudicial conduct, for having been removed from a quasi-partnership company, or something of that sort. But what if the minority doesn't want his shares bought out? Now, this exact scenario happened in a case in which I was instructed, called a legal costs negotiators, where there had been a four-party quasi-partnership, 25% each, and one of the parties, not my client, I hasten to add, I acted for the majority 75%. One of the parties conducted themselves very badly, and he was removed by the majority. And he said, oh, great, that's absolutely fantastic. You carry on working hard, building up this company, and I'll take my 25% benefit in due course, which my clients thought was quite monstrous, because the bargain was that they should all work for this company. We sought to employ the Section 459 jurisdiction in this country to, as it then was, 994 as it is now, to acquire his shares at a fair value, so that all the future work that we put into the company, of us alone, would inure to our own benefit. But we were rebuffed in doing that, both at first instance and in the Court of Appeal. And there is really no mechanism whereby shares can be taken off somebody in these circumstances, unless you unless you either resort to a claim, just a straightforward writ claim form claim, or you have a sort of a provision in articles which entitles you to forfeiture for proper reason. Now, my Lord Hodges' point is he understands the point about detriment to the company, but this is a case in which somebody has failed to bring the benefit to the company that they said that they were going to bring. That on this hypothesis, that somebody in the position of Mr. Charr did make highly material misrepresentations and did not bring to the company the benefit that he was going to bring, in that he was never qualified at the New York bar and had no knowledge of IPOs and so on and so forth, even though he represented that he had. Now, in those circumstances, the company may or may not have a claim, a straightforward claim, as a matter of contract, as a matter of misrepresentation. But it's quite wrong, in my submission, for the majority shareholder to take that up, use his majority shareholding to change the bargain in the articles to introduce a forfeiture mechanism so that he can be judge, jury, and executioner in relation to a material misrepresentation or detriment to the company. I've not seen the like before, I have to say. And when one looks, as we did in the record of appeal at the resolution on page 519, this is a code or a provision introduced in order to, and it wasn't introduced. With blue sky thinking. It was introduced very specifically in a part of a chronology to which I'm just going to refer in a moment. But the material misrepresentation which triggers this expropriatory exercise is either on the basis of fraudulent or negligent misrep. Now, if you had an action, there might be questions as to what sort of relief would ensue in relation to misrepresentation. For example, you wouldn't get rescission for a negligent misrep. You may not even get rescission for a fraudulent misrep. You may just get damages in lieu, and somebody would therefore be entitled to hold on to their property, the shares, the 20% of the company, because the wrong doesn't justify the remedy. So this takes it out of that realm, uses the majority power to shoehorn this provision into the articles, and then has its own jurisdiction, which in my submission is quite wrong and quite dangerous.
Well, the majority shareholder isn't judge, jury, and executioner. He has to establish the circumstances in 3.8a or 3.8b have been properly found. And if there isn't a material misrepresentation objectively, if there isn't an act which may result in the company being suffering prejudice, then the courts can say so.
Well, and of course I have to accept that that's precisely what's happened in this case, because I obtained an injunction in the BVI. And
let me just cut to the chase. What is the test you're asking us to apply then? You say this is outrageous, unreasonable, goes beyond the common law, but none of that is part of any test which we've seen in the authorities. The test in the authorities is whether it was bona fide undertaken for the benefit of the company. And is that the test you accept?
Yes.
Well, if that's right, how do you challenge the judge's finding repeated? He uses that phrase repeatedly. He finds that in this case, it can't be said to have been not bona fide in the interests of Staray, or putting it the other way around, he finds that it was bona fide, in the best, thought bona fide to be in the best interests of Staray.
Yes, in good faith, in the interests of the company, with that being objectively...
Thought to be in the best interests of the company.
Yes, but not if no reasonable person would consider it to be so.
And that's the critical point, isn't it?
Yes.
This is not a jurisdiction, the oppression jurisdiction, to use a shorthand term. This is not a jurisdiction which requires the court to investigate the subjective quality of the shareholders' reasoning, and it would be pretty well impossible to do that in a case where, for instance, there were large numbers of shareholders for many different reasons. So what you have to establish is that no reasonable shareholder could have taken the view that this was in the company's interest.
Yes.
Now, the judge's finding that it could perfectly well have been in the company's interest it makes your submission rather difficult to sustain, doesn't it?
Well, I'll come on to that, and the point that your Lordship makes is exactly what is covered by paragraph 4 of Charterhouse.
Yes.
Which is if your Lordship has a look at that.
Well, in fact, it's paragraph 3 of Charterhouse,
yes,
isn't
but
it?
also paragraph 4, that one can't,
Yeah.
one of the problems of delving into it would be, which is why one doesn't do it, I accept. So let me turn direct then.
I mean, this is effectively, you've shown us the main authorities for this, which are Shuttleworth and American Delicacy.
Now, let me then go to the straight to the judge's judgment as to where we say that it is challengeable. First of all, I do ask your Lordships to dwell upon page 318, because what we have done in our written case is we have faithfully reproduced the facts and the chronology, which is quite important.
Page 318.
Page 318.
Right.
It's page 7 of the judgment.
Yes.
What we have done is, in our written case, which I respectfully commend in this regard, is we have faithfully reproduced the facts by reference only to the judge's judgment. And the most egregious element of what happened is all present on this page. At the top of the page, we have Mr. Chen's evidence being designed to show Mr. Cha in a bad light to justify his later attempts to expel him. That's the end of paragraph 25. We then have, because at the outset of this company, it was all highly speculative back in March. But at paragraph 26, we have, in about May, the prospects for the project began to look firmer. It wasn't until then, and indeed it came to fruition when the company finally obtained its 5% shareholding in HD Mining, the Canadian mining concern, in June. On the 18th of May, paragraph 27, on the 18th of May, there was a meeting between these two gentlemen, at which the possibility of transfer of shares from my client to Mr. Cha was raised, from my client to Mr. Chen was raised, and by Mr. Chen. And then this was a paragraph 28 precursor to a series of events with two strands. The first strand was unsuccessful attempts by Mr. Chen to persuade Mr. Cha to part with some of his shares. That might be described as the carrot strand, but the stick strand is the second one. Alarm, real or pretended, on the part of Mr. Chen about nationality and about ability to practice as a lawyer in the PRC. And of course, all of this absolute pretext feeds very much into the fact that there was no material misrepresentation at all. But I'm dealing with on a different context. On the 19th of May, which is after Mr. Chen first starts having a go at my client's shares, he apparently gets in touch with an unidentified. Mr. Cha asked Mr. Chen to put him in touch with an unidentified lawyer. Mr. Cha's explanation, Mr. Cha didn't speak to the lawyer, but Mr. Chen did, and he says that the lawyer told him that Mr. Cha had a United States green card. Apparently he just volunteered it. So it seems rather odd, but there we are. Mr. Chen says he then told the lawyer that he had a US passport, which prompted the lawyer to tell Mr. Chen that he was unable to practice law in the PRC. And that was the first that Mr. Chen knew about it. But he'd already started trying to get my shares off me on the 18th of May, before this point arose, simply because the prospects for the company were beginning to look firmer. And that's why Mr. Chen wanted it all for himself. Whether, paragraph 30, whether before or after he'd received this advice, Mr. Chen then spoke to Mr. Cha, again raised the possibility of giving up shares. Mr. Cha indicated he was prepared to discuss the topic, but told Mr. Chen to be careful. Mr. Chen says part of his motive was to clean up Staray, which I took to mean end any association on the part of Staray with a person who Mr. Chen says he'd been informed was not qualified to practice his profession in the PRC, which is a total pretext. It was never of any moment whatsoever. It's just something that came to Mr. Chen, which he's latched onto.
Well, this is what you're asserting is the inference.
Yes. And
It's also an inference about Mr. Chen's state of mind, which is the one thing which I thought you accepted. This jurisdiction was not concerned with investigating.
But I am appealing to the reasonable people looking at objectively at this amendment that is introduced by the majority.
But this fact that you've made about the stage, the point you've made about the stage at which Mr. Chen first discovered a problem, assuming that that is accepted, it doesn't go to the question what a hypothetical reasonable person would have thought about whether this might be in the interests of the company.
Well, in my submission, the factual matrix does. And if we then turn on to where his lordship deals with the Allen and Goldreef's point, which is on page 32, starts on page 324, he says at the end of paragraph 59, which is a fair summary in my submission, the last sentence, if, however, the amendment to the articles is so oppressive as to cast suspicion upon the bona fides of those passing it, or so extravagant that no reasonable man could really consider it for the benefit of the company, the court may set the resolution aside. And then he refers to Allen and Goldreef's, and then the case where the defendant is
I
Kershaw.
question whether those are two alternative things. This is page 324.
324.
I mean, is it actually correct to say that that these are two alternative tests? A, is it so oppressive as to cast suspicion on the bona fides of those passing it? And B, is it so extravagant that no reasonable person could really consider it? Surely A is simply one circumstance in which a court might conclude that no reasonable man would consider it for the benefit of the company.
I won't step outside Charterhouse.
No.
But his lordship then goes on to deal with Allen and Goldreef's and other authorities, including Shuttleworth, I took you to. He says at the end of paragraph 67, I don't know whether this is in my favour or not, but I should highlight it, the last sentence, it is clear that evidence of surrounding circumstances is admissible to resolve these questions. So his lordship does accept and indeed affirm that when assessing the whether there has been an abuse of power in the way that one can get into it on the Charterhouse test, that you look at the evidence of the surrounding circumstances. And then he at paragraph 68 refers to that part of his judgment that I'd referred to earlier, interested in cleaning up Staray. But then he, paragraph 69 is his conclusion. Applying those principles to the resolution of the 26th of October, it seems to me that it's not possible for me to say that a company in general meeting can't reasonably take the view that shareholders require their shares as a result of misstatements or committed acts shouldn't have their shares redeemed. That, of course, is as a matter of theory quite right, because if there is a shareholder who is causing detriment to the company, then of course that may have to be removed in a quite proper manner. So he says then, by itself, the amendment is not so oppressive or extravagant as to cast doubts on the bona fides of Mr. Chen in professing the view that it was in the best interests of Staray that Mr. Cha should cease to be associated with it. But if we pause there, of course, by itself, an amendment that a shareholder may be deprived of his shares if the fact of his having shares is causing detriment to the company, of itself is theoretically perfectly okay. Of course I accept that. But that was never the case in this case, and although my learned friend pursued it below, he hasn't pursued it here. There's never been any question.
But the judge is looking at them as alternatives, isn't he?
He is.
Detriment is one alternative.
Yes, it is.
And quite separately, which he takes first,
Yes.
shareholders acquiring shareholdings as a result of misstatements, whether fraudulent or negligent, I think that means, or even innocent.
Yes.
is another.
I agree, but my rhetorical question there is, well, why should that be the case? Because if there is on this hypothesis no detriment to the company, why should those shareholders not be entitled to retain their interest in property? Now there is perfectly good reason, there's perfectly good route and remedy for them to be deprived of their property if there is a contractual claim for misrepresentation on behalf of the company against the shareholder, that it should be rescinded or something else like that. But there might be damages for misrep.
Paragraph 69 is basically, read as a whole, a finding that a reasonable shareholder in general meeting could have taken the view that people who had acquired their holdings as a result of misstatements should be deprived of their shares. Now, what he is doing, surely, is he is essentially applying points 3 and 4 of the Etherton statement.
Yes.
And he is saying in those circumstances the subjective bona fides of Mr. Chen doesn't matter. The charge of malice falls away.
But I've been dealing with this on the basis of the words by itself and looking at this rather hypothetically. What this doesn't do is it doesn't plug in to the facts that His Lordship has just, the factual chronology that His Lordship has just found.
Well, I mean, you're saying that the judge's conclusion that no reasonable person would think the matter, that a reasonable person would not think the matter so oppressive, extravagant as to cast out on bona fides, was itself unreasonable.
Well, you can't judge these things in the abstract. You have to judge them on the facts of the.
But he's been through the facts. He knows what they are. He's set them out at considerable detail.
Well, that's exactly right.
And the surrounding circumstances that he refers to at the end of paragraph 67, that's not the surrounding circumstances that suggest that there may have been a lack of bona fides. They're surrounding circumstances that enable one to say whether the amendment could have been for the benefit of the company. Because if the answer to that question is yes, then the question of malice doesn't arise.
Well, and I suppose if it's possible that they could have been for the benefit.
Is that right? I mean,
it does arise, surely. You have to show bona fides.
I mean, surely you're missing a step, aren't you? I mean, where does the judge find the first element of paragraph 4 of the Etherton? The view of the shareholders acting in good faith of the proposed alteration is for the benefit of the company. Where does he find that Mr. Chen, in good faith, thought it was for the benefit of the company?
Well,
because he rather oddly says the bona fides of Mr. Chen in professing the view. He rather dodges actually making any find of whether he did.
Well, you see, this is
At the top of the page, he says he doesn't need to make a finding as whether he's telling the truth.
This is my point. It doesn't. This part of the judgment doesn't marry the law to the facts.
Yes, I mean the point I'm putting to you.
Yes.
I don't know if it's a good point or a bad point. Is that you could be saying that whether it's reasonable or not doesn't really come into play until you've decided what he was actually thinking.
Well, that's right.
You've got to decide. Well, did Mr. Chen genuinely think that this was the best interest of the company?
Because it has to be. This is very fact specific, and it has to be in accordance with the facts of the case. Because obviously, if one looks at the resolution, the amendment to the articles in the abstract, one cannot complain about about an article which says that if the shareholder qua shareholder is doing detriment to the company, his shares should be removed. But the introduction of such a thing, and that might be fine in the abstract, but if there is no justification whatsoever to introduce such an amendment, because this is not a company in which the identity of the shareholder is doing any detriment or can do any detriment to the company, what is the purpose of such a provision?
Well, he doesn't actually find, does he, that it couldn't do any detriment to the company. On the contrary, he says that it would be possible reasonably to take the view that it might.
Well, but this is all theoretical. We must deal with the facts.
But the theoretical question is the one posed in Shuttleworth, quite conveniently summarised, at points 3 and 4 of the Etherton statement. You ask yourself whether any reasonable person could have taken the view that it was in the interests of the company. And you ask that question precisely because what the court doesn't do is investigate the quality of the subjective views of the shareholders. And the surrounding circumstances to which the judge refers at the end of paragraph 67 can't possibly include the subjective quality of the views of the shareholders, because that's the very aspect of it which is not part of the test.
Even if, can I just put a further possibility, even if that's not right, and that you are concerned as a first step with whether it's in the best interests of the company, or whether it's thought to be, isn't the onus on you to establish the contrary? And isn't that what the judge is saying in the middle of paragraph 69? By itself, the amendment is not so oppressive or extravagant as to cast doubt upon the bona fides of Mr. Chen in professing the view that it was in the best interests of Staray that Mr. Shah should cease to be associated with it. So his starting point is Mr. Chen's evidence that he was acting in the best interests of Staray, and he's asking, is there anything to throw doubt upon the bona fides of that, the credibility of that? And in that context, of course, one would consider whether this was such absurd evidence that no reasonable person could consider it to be true. But isn't that the way he's dealing?
Of course, and in other contexts, I have, with respect, commended the learned judge's findings of fact, and commended them to your lordships. And if it be that paragraph 69 is more than theoretical and involves findings, notwithstanding the findings that he's made about the energetic efforts to blacken my client's name and all the rest of it, that these and the point at which the majority shareholder, the only other shareholder, introduced using his powers these amendments to the articles, and notwithstanding all of that and the point in the chronology and wanting to rid the company of my client, if nonetheless that his lordship has found that Mr. Chen is bona fide and this is in the interests of the company and that a reasonable person would consider it to be so, then of course I am undone. But when one looks at the test in Charterhouse about in the interests of the company and no reasonable person, this isn't all merely theoretical in my submission, because one couldn't possibly gainsay an article or the introduction of an article which had an expropriatory provision in it in relation to a shareholder who was not a fit and proper person and upsetting a regulatory license or something of that sort. But the interests of the company and the reasonable person have to be in accordance with the facts of the case. It's not all merely theoretical, that this might be a theoretically very good article, because if there is no prospect at all, and this case has been, this notice was served in October 2011, and 6 years on, despite endless introduction or trying to introduce new evidence, the one piece of evidence we don't have is any detriment to the company whatsoever about anything that my client has done or has said to have done. Now, in those circumstances, the introduction of that article about an article about detriment and expropriation is very odd indeed, because it's just a pointless thing.
What
it
that
might
amounts
theoretically be a good thing, but it's utterly pointless. So why was it introduced? Well, that's the question.
Well, you say it's utterly pointless, but that involves a submission, doesn't it, that it could not possibly be in the best interests of Staray that Mr. Cha should cease to be associated with it. And in the case of an 80-20 company, where relations between the shareholders are as important, or certainly almost as important as relations between the directors, I'm not quite sure how you get to that proposition.
Well, I get to it in this way. in fact, in a company such as this, the relationship between individuals qua shareholder is really neither here nor there, especially if a shareholder is an 80% shareholder, and that this is not actually subject to any special resolutions or anything like that, but even if it was, an 80% shareholder would overtop that. And the rights of a minority shareholder are very slim in these circumstances. They're slim here, let alone in the BVI. And in those circumstances, the majority shareholder carries on. The question is, why should my client be deprived of his property rights in the shares? Now, the point that your lordship is making might come quite close to saying, well, the majority shareholder would be happier if my client didn't have any interest in the company. And so when this mining concession comes to fruition in Canada, he is not going to get 20% of 5% of HD mining, which could be very valuable. And no doubt Mr. Chen would be happier if he'd been able to buy out my clients at a fair value before that mining concession comes to fruition, because a value now is going to be considerably less than a value when the mining concession comes to fruition. And I don't want to lose my property rights. I have my property rights, I have my shares, and I want to sit on them. I didn't want to be removed as a director. That's all down to Mr. Chen. But why should my shares be expropriated? It's nothing to do with the benefit of the company. It's all to do with the benefit of Mr. Chen in the circumstances. That's the point. And the fact that somebody might be happier if they're able to expropriate or confiscate or forfeit a fellow shareholder's shares so they don't get any benefit of a future upside is not, in my submission, an appropriate bona fide
I think...
and I can't really take them.
We probably got that point.
Yes, quite.
It's not a question of happiness.
well, it is a bit, because he wants to rid...
Yes, well, you submit it is that he just wanted to get rid of him, and that's it.
That's right. And when the reasonable person comes to look at the circumstances of this case and to judge Mr. Chen's bona fides, it all points one way. There's no proper basis or reasonable basis for the removal of for the compulsory redemption of my client's shares in these circumstances. However theoretically good the amendment to the articles may be, and I would in any event query the theoretical good that could arise from an article which could redeem on the basis of material misrepresentation. I entirely accept the theoretical good that may come from a redemption on the basis of detriment. But material misrepresentation, i.e. some point about bargain, that's not something that necessarily should be because the company is saying he hasn't got quite what it bargained for with my client not being so good at IPOs. Why should that lead to the compulsory redemption of my shares? And why should it overtop an ordinary action for misrepresentation?
Can I just ask you this question? Your submission is very heavily dependent on the particular facts about the relationship between Mr. Chen and Mr. Cha. But this amendment was there to take effect as between any people who might be shareholders at the relevant time. Now, if the amendment is at least capable of being a perfectly reasonable amendment in the generality of cases, is it possible to strike it down because the actual occasion for its introduction was a particular case which is characterized in the way that you've just described?
Yes, because when you go back to the very fundamental of this, which is Allen and Goldreef's, it's all about abuse of power. Abuse of power of the majority in the minority in the particular circumstances. It's not about theory, it's about the particular facts. And the particular facts are as they are here. And on the facts, there was no contemplation that this would have... I know I have to be careful about saying it was directed towards Mr. Cha, because that is not
I think
the be-all and end-all.
It was.
It was. He
Chen admits the resolution was directed at Mr.
Exactly.
Cha.
And that
he was interested in cleaning up Staray, he says, meaning ending any association of Mr. Cha with it.
That's right. And I can't say that is mala fide per se, but it's a very important element in the factual circumstances by which one judges the reasonableness of whether this was bona fide, and somebody in these circumstances, in this particular case, can say that a reasonable person could say that this was in the interests of the company to introduce this. It just wasn't.
Where in the evidence we find that reference to cleaning up?
Paragraph 68.
Yes.
Findings of the judge.
No, I know we find it there.
Yes, it's paragraph 68, and it's also in paragraph 30.
Where is it in the evidence?
Well, no one's challenging the judge's
Do you know, I
findings.
don't.
I just thought the context might give us some help as to what it actually meant. Because it's not
Well, no.
Anyway, if you can't, doesn't matter.
Well, no. I mean, and the judge says part of his in paragraph 30, he says Mr. Chen says that part of his motive in exploring these steps was to clean up Staray, which the judge took to mean end any association, and it was certainly directed towards Mr. Cha. That's also in paragraph 49, and then also the reference that my Lord Mance gave about it.
No, I've seen that. I just wondered whether it's obviously something he said somewhere, either in his...
Yes, I can't put my finger on it, but I just rely upon that in the
Mr. Conner, can I take you back to
Charterhouse.
Charter?
Right, well, are we nearly there?
Yes, we are.
More than a quarter of an hour over your 25 minutes.
Beg your pardon.
No?
But my Lord Briggs wants to detain me one moment further.
Right.
And in particular, his points 3 and 4 in paragraph 90 of his judgment, where there is a fairly firm direction, providing the shareholders' decision satisfies what one might call a sort of Wednesbury test, that you don't actually inquire into the thinking, state of information and so forth of individual shareholders. The way I think I understand your submission addressed to the facts of this case is that there may be something of an exception to that if there is only one shareholder and he's before the court, and one can actually, in a perfectly ordinary forensic exercise which treats one's state of mind as not dissimilar to the state of one's digestion, find out what his intentions and attitude and reasons, if you like, for the proposed amendment actually were. Because you say, well, it's all very well in theory to say that an amendment like this could be for the benefit of the company. I find it difficult to challenge the judge's assertion to that effect. But you say that's all pie in the sky because here we've got one shareholder and we know what's going on.
Well, my Lord, with respect, I would agree with that, and I have stressed that there are only two shareholders here. One is an 80% shareholder, one is a 20% shareholder. And so, yes, one is able to get to the nub of the issue very much more easily because everyone's before the court and we're not inquiring into various motives or knowledge that there may or may not be at a general meeting or involving a number of people. But in any event, when one looks at no reasonable person would consider it to be such in paragraph 3 of Sir Terence Etherton's judgment of those principles, that's not a reasonable person considering this thing, considering such articles or the exercise of the power in the abstract. It's considering
a reasonable person in the position of these shareholders.
Yes, it means on the facts of this case.
That's quite a different. I think moving from in the position of these shareholders to on the facts of this case is moving from the objective to the subjective.
Well, that might be, but of course it's in fact this shareholder, which is the point my Lord Briggs made. But I don't think that I can take this any further, and I'm much obliged to you.
Yes, Mr. Chatlani. Yes, Mr. Atherton.
My obliged, my Lord. Just very quickly before I forget, my Lord Carnworth was asking where the clean-up reference came from, and it comes from the cross-examination of Mr. Chen. Yes. The page references are page 1075, line 19. That will give your Lordship some context.
Thank you.
Over the page to 1076.
Right.
First of all, my lords, could I take you to a document which I meant to take you to about 3 minutes into my submissions this morning, which was just to deal with some of the context. It may not matter, but just to complete the picture. If your lordships could kindly go to page 572 in the bundle. Now, this was simply to show the context of what was being discussed and negotiated at the time. And your lordships may recall I said the meeting was on the Friday, and then this document was sent by Mr. Chen, copied to Mr. Cha, to the company and the firm which was responsible for incorporating the company. And you'll see there that essentially what's happening is Mr. Cha is receiving 20% shareholding, and in essence because he's becoming the general counsel to Staray. So that just corroborates, in fact, what was happening in the context at the discussion merely at the end of the previous week. Then if I could deal quickly, returning, if you like, to the vexed question of the New York licensing, New York qualification. My learned friend in the course of his submission said, well, what that's intended to achieve, amongst other things, is to prevent someone in Mr. Cha's position, someone whose licence has been suspended, from holding himself out as qualified to practice as a New York attorney. Well, that's in fact what Mr. Cha was doing at that meeting by making the representation that he made. Because he wanted to take the engagement and share in the shares of Staray, which was the company that was going to be participating in the project. And if I just pause there to pick up a number of points that my learned friend has made, he continues to assert before your lordships that Staray was a dormant holding company. That wasn't found as a fact, and in fact there was a continuing debate before his lordship as to what Staray was. It was always the position of my client that Staray was a company which, yes, held a share in the project, but was to be available to participate actively in that project, insofar as it became necessary or appropriate for the purposes of furthering the mining project in Canada. So it's not set in stone or set in aspic that this company is dormant and merely a shareholding company. And on that basis, it's pure speculation on behalf of my learned friend to say, well, therefore there could never be any harm done to this company by Mr. Cha or anybody else. Well, it's a normal commercial entity with a prospect of participation actively pursuing its interests, preserving its interests in the project in Canada. Returning, though, to the New York qualification, it's essentially a repetition, forgive me, the point I've previously made, which is one talks about if I retire from the bar or the bench, can I continue to give legal advice? That's fundamentally different where you are in breach of the code of ethics or the professional conduct rules of your profession. And the regulator, or in this case the court, imposes a sanction forbidding you to operate in an area where you were previously licensed or sanctioned but are no longer. In my submission, that is a fundamental difference. Then if we could go, my lords, back to the judge's judgment in Bundle A. Now, in my submission, there was an element of inconsistency in the judge's reasoning about what was important to Mr. Chen. And that inconsistency can be seen at paragraph 9 at page 314, when compared to paragraph 74 of his findings at page 328. And it's with respect to this. At paragraph 8, he talks about, paragraph 9, I beg your pardon, he talks about the discussion, or one of the issues being that Mr. Cha was involved in capital markets and IPOs. But then he says, and this is at the meeting, that in fact he doubts very much whether IPOs were ever discussed at that moment in time. And if that's right, then his conclusion at 74 is inconsistent with that finding when considering what the position was at that moment in time on the 20th of March. Because having said he doubts whether or not those were discussed, he then says that's what Mr. Cha, or rather Mr. Chen, was relying upon. Now, it may very well have been that he was relying upon it subsequently, but at that meeting, what was important to Mr. Chen was Mr. Cha's legal qualifications, both in the PRC and in New York, and his status as a partner in King & Wood.
But the fact that it wasn't discussed doesn't mean, say, it wasn't an attraction on Mr. Chen's part, does it?
But there's no indication.
I mean, he's found in paragraph 8 that it was an attraction, and in paragraph 9 he says it wasn't discussed at this stage, but it doesn't mean to say it wasn't an attraction.
No, I accept that, but the specific representations that were being made, the judge seems to be finding, was not in relation to any IPOs. It may very well have been that no doubt Mr. Chen was aware of Mr. Cha's expertise in that area, but it's not a specific statement that's being made by Mr. Cha at that meeting, which Mr. Chen is putting value on.
No, and indeed that's what the judge is saying, because there isn't a representation relied on about IPOs. The judge is simply recounting what it was that did interest Mr. Chen about Mr. Cha. And there doesn't need to have been any representation. He could have just looked him up in the book and found that he was an expert in capital markets and IPOs and said to himself, that could be interesting in the future, without mentioning it.
Very well. It may be that I'm taking a bad point. My concern is in my submission, that the interest in IPOs and capital markets does not detract from the importance of the representations actually made at the meeting. So there may be a temporal issue there, but that's essentially what my submission is. Now, your Lordships may recall that I lost my reference to a document which I thought might assist in relation to the importance of King & Wood and the partnership of Mr. Cha. Could I ask your Lordships to go to page 11 and 12 of the bundle? I don't think I took you to this document. This is an extract, or this is part of Mr. Cha's affidavit of the 4th of November, and it's really paragraph 5. I'm a partner in King & Wood, one of the most prominent firms in China. Because of my background, part of my role in the joint venture with Mr. Chen was to offer our business partners and affiliates a sense of substance and assurance of proper conduct, and to introduce them to appropriate players in the capital markets. So in my submission, what that is doing is aligning what Mr. Cha's role will be in the company with his status as a partner in King & Wood, and that's why Mr. Chen was interested in that status. Then, if we return to paragraph 74 of the judge's judgment, just to make a point about what is it that I would submit the new evidence might go to, that I've applied to put before your Lordship. It would deal with, in part, the point which is made there by the judge in the first part of the paragraph. Quite apart from that, while I found that Mr. Cha told Mr. Chen that he was a partner in K&W and qualified to practice in both PRC, which he was, although, as will be seen, there are questions whether he should have been. His Lordship wouldn't have made that comment or raised that doubt if he'd have had the information available to him at that point in time.
Well, I was just looking at some of the things which were said in one of the statements which was before the courts, before the judge. Somewhere there is a closing submission, which raises all sorts of suggestions of lack of qualification and I think misleading on the basis that he knew he wasn't a Chinese citizen and so on. Can you just identify where?
Well, I'm guessing it will be my closing submission.
Yes, it will be your closing submission somewhere. There doesn't seem to be an index of these bundles, which is not the most helpful thing. So once one's lost a bundle, a document, one's lost it.
My written closing submissions, my Lord, on appeal were at page 430-1, which is the electronic reference.
We have
Yes, I actually had in mind, I think, page 227, but let's just look at
I beg your pardon.
430, you say?
Well, they are just my closing submissions for the Court of Appeal.
Oh, I see, yes, the new one, yeah. No, I think I was looking at page 227. This is your client's witness statement just before the trial. So it's September 2012. And if you look at paragraph 919, I believe I've established Mr. Cha lied to me and others about being a lawyer qualified to practice Chinese and US law. And then he's reported his concern to the Beijing Municipal Bureau of Justice. And,
that's right.
There's been an opinion which concluded he breached Chinese law. He says he's had a confirmation, etc. He says he hasn't established a truth in order to harass Mr. Cha. He's concerned he was breaking Chinese law. Well, you actually had plenty of material to put to Mr. Cha that he'd obtained his Chinese license fraudulently. And that's the one thing which the judge recounts at paragraph 85 you didn't put to Mr. Cha.
Well, with respect, my Lord, what they are allegations that are made by Mr. Chen.
Well, you say you pretty well got it sewn up. You believe, you say, that what your client says. So why couldn't he put it? Why couldn't you put it?
Well, perhaps I should have done. I didn't think it was appropriate because I didn't have any firm material on which I could say that Mr. Cha had misled the Chinese authorities.
If you put it by way of submission, you must have had material for putting it by way of cross-examination.
I didn't actually put it by way of submission, to be fair, my Lord.
Right.
For that reason.
The allegation, I think, was raised by Mr. Chen's lawyers very early on.
Yes.
And the word fraud was used, but when it came to the trial, you didn't have the material professionally to raise the fraud.
That was rightly or wrongly, that was the view I took.
Yes.
And it was only when material came out subsequently in terms of findings by regulators or judgments of courts.
Well, I mean, it's professionally good that one doesn't pursue these charges if the evidence isn't there.
Well, I may or may not have taken the right decision, but that was the decision that was taken.
But I mean, is the material now, what's the material now based on? It's based on the fact that he wasn't qualified, from which a conclusion is deduced that he must have known he wasn't qualified and must have defrauded the authorities, or is it based on some finding following his giving evidence to the Chinese regulator?
Well, it's the new documents you're wanting to put in today.
That's right, which is...
But the new documents show that he did give some evidence to the Chinese regulator.
That's right.
Is that what makes the difference?
Yes, I think it is, because
But he was
even when we had... I'm sorry, my Lord.
He was disbelieved by them, you say?
Yes. When the experts were giving evidence, there was a dispute about whether or not, if you had obtained US citizenship, you immediately forfeited your Chinese citizenship. and therefore were precluded from practicing or holding any valid certificate or certification to practice Chinese law in China. And it now transpires that the situation was that indeed Mr. Chen held US citizenship, but we knew this, that precluded, according to the authorities, his ability to have obtained a practicing certificate. And if they had known about his practicing certificate, if they had known about his acquisition of US citizenship, they would not have given him a practicing certificate.
Can you remind me in the chronology, when did he first get his Chinese certificate?
He attained US citizenship in 2001, and thereafter, I think in 2005,
Yes.
he acquired his practicing certificate. And then there is a renewal process. And the Court of Appeal, I think, found that if he disclosed his US citizenship on the renewal process, then he wouldn't have obtained his practicing certificate.
Do we have the law opinion which was available at the time of trial of De Heng law offices, which was that Mr. Cha had breached Chinese law?
I don't think it's in the record before your lordships.
No.
That wasn't an official expert report. That was simply an opinion from lawyers that was obtained by Mr. Chen.
Yeah, but presumably it was on the same basis that you say is now shows that he was actually acting illegally.
Yes. But of course, when it came to leading expert evidence at trial, then there was a dispute between the experts as to whether or not, in effect, the De Heng opinion was correct. And ultimately, the judge didn't determine the issues. He didn't feel able to, and it was only the Court of Appeal, on the basis of further evidence, who were prepared to accept that there had been a misrepresentation as regards Mr. Charles' status.
What is the evidence that Mr. Cha knew that this was the position?
Well,
you're saying that the new evidence takes it further in the sense that it would have given you a foundation to put to him fraud. That would assume that the evidence shows that he knew it.
Because it would have been plain, or what is now plain, we say, that Mr. Cha knew that his US citizenship and acquisition of citizenship precluded him.
Right, how do we know that?
But this gets back to our discussion this morning that you say you have these findings. But you've recognised this morning, as I understand it, that they wouldn't self-prove the facts that were found by the Chinese court, and therefore they would have been available to you to cross-examine Mr. Cha, but you're not asking for a retrial. Therefore, I really don't see where this new evidence takes us.
Well, with respect to my Lord Hodge, I think that's right.
Well, then why are we bothering? I mean, that's...
Well, I'll draw it to a close, but in answer to, I think, Lord Mance's question.
Now, I think, can I just say, I think I'm wrong in saying that Mr. Cha was ever interviewed by the Chinese authorities. It all appears, this recent investigation, to be done on paper, doesn't it?
Well, but I think some information, as I understand it, some information has been provided by Mr.
Is that apparent from the document itself?
I think the answer is off the top of my head now. I can't tell you.
I'm sure your client supplied as much information.
Yeah, I'm sure that's right.
Yes. Right. Anyway,
just to.
You were going to say something.
I was simply going to say that the De Heng opinion is indeed in the record. I think it's at page 656 through to 660.
Thank you much.
What may help the inquiry that Lord Sumption made, and I think was being endorsed by Lord Carnwath, is that in the administrative judgment, which is dated the 15th of April 2016, which is one of the documents I seek to have admitted, Mr. Char is the plaintiff. So he has brought those proceedings, essentially to challenge the administrative judgment that was made against him previously, and which annulled his practicing certificate.
So which one is that?
It's in the supplemental bundle, which I think your lordships have. It's page 43, and it's quite a long, well, relatively long. It's 12 pages. It finishes at page 54.
Yes, and he's stated there to be plaintiff, yes.
That's right.
Yes.
Now, my lords, I was then going to move on to the Bene essay submissions of my learned friend, Mr. Collins, if that's appropriate.
Ah, well, he's only a plaintiff because he's an appellant.
He's an
Yes.
appellant, yes.
Yeah.
Yes.
Yeah. Yeah. Yeah, sorry, carry on, yes.
So, my lord, I was then going to move on to the Bene essay issue.
Yeah.
Now, we do say, by way of preliminary objection, that, as I said this morning, what Mr. Collins is seeking to do is to bring a substantive appeal. One way of testing this is he's asking your lordships to analyse again the facts and the authorities which were considered by the judge and the Court of Appeal. One, obviously, at the trial, the second, which he raised by counter-appeal before the Court of Appeal. But his way round having to comply with the procedure of this court is to simply say, oh, well, I don't want any relief. But then what is it he occupying your lordships for?
Well, he must want relief in the sense that he wants to reverse the judge's conclusion that no further relief should be given under paragraph 1 of the prayer. And he wants a conclusion that the amendment was invalid. He may say, well, I'm not interested in having that written out in there's so many words. All I want is a conclusion that the appeal fails. But it will fail because the amendment's invalid rather than because it's valid and there was an invalid notice under it.
In which case...
And we have to analyse that. It's as short as that, isn't it?
Yes. But in my submission, therefore, what my learned friend, as counsel for the respondent, is seeking to do is to seek to argue that the order appealed from should be varied.
Well, that's what the question is. Is he really seeking a variation of the judgment below?
Well, in my submission, he must be, because otherwise, what's the function of your lordships in relation to the submissions that he's been making to you?
We couldn't just say the appeal fails. We'd have to give a reason, and the reason would be on his case, namely that the amendment was invalid. And that's a different conclusion from the one the judge reached.
Correct. But that would have required him to go through the process of issuing a cross appeal.
Yes.
That's my point.
I think we understand your point.
I'm sorry. But my second point is...
It's not a respondent's notice situation. It's which doesn't exist in the Privy Council at the moment.
That's right. But the procedure for what he's seeking to do exists.
It's a cross appeal.
And moreover, my Lord Carnwath picked me up on the point in terms of the correspondence where my Privy Council agent indicated, well, you can put your points in your written case. Well, that depends on the understanding of what was trying to be achieved. It can go in the written case if it falls within sub-paragraph or sub-rule 1 of Rule 25. But otherwise, it must fall within sub-rule 2.
Yeah.
And it's not for me, in any event, to waive that. This is a fundamental requirement of the procedure of this court. I can't take it upon myself to waive the need for a respondent to obtain permission to appeal. That's
Yes.
not for me to deal with.
Well, you may have encouraged a certain state of mind which might induce some sympathy if it were the case on the part of the court, but we'll have to consider that.
Of course, my lord. And to some extent, those preliminary objections are developed in my supplemental written case, so rather than take up time now dealing with that. It's also important to point out that the submissions that your lordships have listened to today from my learned friend are essentially the submissions that he made to the judge and to the Court of Appeal. And in my submission, that further exposes the reality of what my learned friend is seeking to do. However, if I could then just go to the substance of what my learned friend was seeking to deal with. First of all, he seeks essentially to refer to the Daffen tin plate case as some sort of factual precedent. To be fair to him, he did say that it's dangerous to rely upon it in any sort of jurisprudential context. And the reason for that is twofold. First, because Mr. Justice Pearson applied the wrong test. He applied an objective test. And secondly, and with respect to my learned friend, he fell into the same trap as Mr. Justice Pearson did in the Daffen tin plate case. Because in Shuttleworth and Cox, it was made plain that the test that was applied in Allen and Goldreeves was not a bipartite test. It wasn't twofold, it was one test. So it's not split up in the Charterhouse case, and my learned friend was wrong to say you have two aspects of it. It's simply one test, which is whether or not the majority shareholder was acting bona fide in the best interests of the company. I don't take any issue with the statements of law in any of the cases. And as Lord Hoffman said in the Sitco case, which is Bundle 1, Divider 12, at paragraph 18, the well-established principles. Could I also make the point I should have made just a moment ago? The learned judge at paragraph 61 picks up the point that was made in Shuttleworth and Cox, that it is only a unitary test. It's not a bipartite bifurcated test. My learned friend has taken me to task and referred your lordships to the authorities dealing with what the role of an appellate court at this level is in relation to findings of fact of a judge, particularly where you have concurrent decisions, one of the first instance court and one of the Court of Appeal. But what I was seeking to do with respect, as I tried to indicate, was qualitatively very different, which was to draw together the evidence and not really challenge the principal findings of fact by the judge. It was, with respect, slightly more nuanced than that, and to deal with his evaluations of those facts and the inferences which he could or failed to draw, rather than determinations of primary facts. What my learned friend is seeking to do is very, very different. And Lord Mance, with respect to his lordship, warned against this in the Ecuador bank case, where he says that, and I intimated or alluded to this morning, there should be great caution in a court at this level, challenging determinations where a judge has found that a party has acted with probity. And what this court is being asked to do is to find, in fact, that Mr. Chen has acted without probity, that he's acted in bad faith or with an absence of bona fides. And I think the easiest way to address my learned friend's points, with your lordship's permission, is to go to the judge's judgment and consider relatively quickly the relevant findings paragraph by paragraph. The judgment begins at page 312, but for these purposes I think we can start at paragraph 49. The starting point for the judge was that in cross-examination, Mr. Chen denied that the amendment was discriminatory, since it applied with equal force to himself and to any other shareholder to whom Mr. Chen was to transfer a single share. In particular, was a single share transfer on the 17th of February 2012. But, of course, this change in the articles applies to any shareholder who acquires shares after its incorporation into the Articles of Association of the company. So to that extent, it is not in any way discriminatory. The learned judge heard Mr. Chen give evidence, and Mr. Collins cross-examined him extensively. And there is no finding in the course of the judge's judgment that Mr. Chen did anything other than act bona fides in the interests of the company. And in particular, paragraphs 68 and 69, which I know your lordships have been to already. But if we look at, for example, paragraph 69, the second half of the paragraph, by itself the amendment is not so oppressive or extravagant as to cast doubt upon the bona fides of Mr. Chen in professing the view that it was in the best interests of Staray and that Mr. Cha should cease to be associated with it. Now, pausing there, that it must be inferred, and it's reasonable to infer, that the judge is starting from the premise that on the basis of the evidence he's heard and the facts that he has found, Mr. Chen's assertion, which we've seen in paragraph 49, of acting in good faith, is correct. So it's an actual finding on behalf of the judge of the bona fides of Mr. Chen. And then he goes on to say to test it in the way that Lord Sumption was testing it with my learned friend Mr. Collins, that one then applies to see whether or not you can undermine the asserted bona fides by reference to whether or not what has occurred a reasonable person would consider to be out with the notion of good faith in the context of the resolution that's been passed. Now, all the cases were concerned with ex post facto, all the cases the Lordship has been taken to, were concerned with ex post facto changes in articles which were dealing with a specific purpose that had, or a specific set of circumstances which had befallen that particular company. So, for example, in Allen and Gold Reefs, the situation there was one shareholder who had fully paid up shares, and they required to obtain liability for contribution to the company. So they imposed ex post facto a lien on fully paid up shares. There was only one shareholder that could apply to, and it was directed specifically against him. But in the circumstances where it was necessary for shareholders to make contributions, it was considered to be appropriate, bona fides in the interest of the company. I think in the Shuttleworth and Cox case, it was concerned with, I think, a director who they wanted to remove. So they changed the articles in order to remove him. Again, the court was reluctant to find that in the circumstances there was any lack of good faith on the part of the majority shareholders. And in, I think, the Sidebottom case, and I'm not sure what Lord Mance's particular pronunciation of that was. But again, the issue there was a reason given, and that reason was because these shareholders were in competition with the company. Now, my learned friend continues to raise the point that the way the judge dealt with this was theoretical. Well, with respect, that's wrong. That the judge has reasoned through all the relevant facts and applied the legal test to the facts that he has found. There's nothing theoretical about it. It's actuality. And on that basis, he accepted that it was reasonable and couldn't fall out with the bounds of what was in good faith for a company to say, well, if a shareholder acquires shares through a misrepresentation, then it's appropriate for those shares to be expropriated. Now, pausing there, if my learned friend said, well, the obvious alternative is that the company could simply bring an action for some sort of remedy in respect of those shares, that remedy might be rescission. But with respect, that would give, to personalise it, Mr. Cha less protection than he has in relation to the resolution that's been passed. Because here, it has to be established, one, that there was a misrepresentation, and if there is, he is to be bought out at fair value. If the contract for the allotment of shares was rescinded, then it's as if the contract hadn't existed. The parties would be, there would be an attempt to put the parties in the position they would have been had the contract not been entered into.
Yes, and the resolution doesn't give a remedy for innocent misrepresentation. It's only fraudulent or negligent.
That's right.
Yes.
That's
so
right.
if you're fraudulent or negligent in your representations, you'll be bought out at market value. That's the deal.
Fair value.
Fair value, sorry.
That's right. That's right. So in fact, it gives greater protection
Yeah.
because it could be that Mr. Chow would get nothing, even were you're seeking to do restitution. The findings of his lordship in the paragraphs that your lordships have been taken to are that there was an absence of mala fides on the part of Mr. Chen.
He never actually finds that, but I think that must be implicit. And in fact, I mean, the passage you referred me to in the cross-examination I thought was quite helpful because it shows what was meant by cleaning up,
Quite.
which is precisely, in effect, what we talked about at paragraph 49.
Yes.
And Mr. Chen wanted to clean up because he thought there was someone who was made material misrepresentations to get his shares, and he thinks that's not good for the company. That's what he says.
Yes.
And I don't think it's ever questioned that that's what he bona fide thought.
Absolutely.
I mean, if it's now found out that in fact they weren't material, well, that doesn't necessarily affect the bona fides of what he was doing at the time.
No, at the moment, of course, my lord, the position is that the
Well, that's
resolution...
why I only put it because that seems to me that explains why the judge treated the only material issue as whether it was unreasonable in the sense of the authorities he was looking at. He was accepting that the reasons were as set out, and the question was those were reasons could be reasonably held.
Absolutely, and he faced full frontal that explanation by Mr. Chen, and in the face of that explanation found that there was no lack of bona fides, there was no mala fides, and by applying the reasonableness gloss that one applies, that it was within the ambit of what a reasonable person or reasonable shareholder would consider appropriate.
Right.
When you said fair value, it's fair market value, but importantly, without any discount for minority status.
Yes.
So it, on one view, it's quite a generous form of valuation
Absolutely.
for a minority shareholder.
I absolutely will, my lord. I agree with you entirely. What my learned friend was actually quite anxious not to do was to really challenge any of the findings of the judge. With respect to my learned friend, what he was doing was applying a theoretical approach to the problem which faced the judge, whereas the judge was dealing, as I say, with the reality. And my learned friend's, if you like, justification in the upshot of his case was, if this was a case about poor performance, why should poor performance require expropriation of the shares? Well, because Mr. Cha didn't deliver, as far as Mr. Chen was concerned, what he had been promised by reference to the representations. As far as Mr. Chen was concerned, Mr. Cha wasn't qualified in the United States appropriately. He shouldn't have been qualified in the PRC, and he wasn't a partner in King & Wood. I think, to your Lordship's relief, I've drawn to a close. I think they're the submissions that I have, unless your Lordships have any particular questions.
No, thank you very much indeed.
I'm obliged.
Yes, Mr. Collins. Reply on the question on which you are entitled to reply.
Well, no, I've nothing further, my lords. Thank you.
Well, the board is grateful to council for getting through de beniesi in one respect, all the issues, and will take time to consider what advice it will humbly tender to Her Majesty.
We're much obliged to you.